Sida Patent Chat Number 10. We will look at a patent litigation between Chef America against Lamb-Weston. Take note that the main issue will be the wording, heating to versus heating at. This is the patent. A process for making dough product. Patent owner is Chef America, founded in 1970. It is the manufacturer of the microwavable snack, Hot Pocket. It was acquired by Nestle in 2002 for $2.6 billion. This invention was meant to be kept in a freezer. It can be cooked by using a microwave oven. Although there are already a number of products in the market, most of it was unable to create a light, flaky, crispy texture. The cooked product was usually leathery or soggy. One way to overcome this problem is to use a microwave susceptor. Susceptor improved the situation but frequently result in hard, crusty surface. This invention will overcome this problem. To understand the invention, we first need to understand two things. Dough and batter. Dough is made from flour that is mixed with liquid. Batter is a mixture of flour, egg, and water or milk. The patent has 5 basic steps. First, prepare a dough. Next, apply a shortening flake to dough. After that, coat light batter over dough. Heat the dough to 400 to 850 degree Fahrenheit. Lastly, cool it down. The litigation will focus on step 4, heating the dough to 400 to 850 degree Fahrenheit. Chef America is the plaintiff. Lamb-Weston is the defendant. Lamb-Weston was founded in 1950. It was one of the world's largest producers and processors of frozen French fries, waffle fries, and other frozen potato products. Defendant argued that Claim 1 is invalid, therefore there is no infringement. Let's look at Claim 1. This is the issue. Heating the resulting batter-coated dough to a temperature in the range of about 400 degree Fahrenheit to 850 degree Fahrenheit. Defendant argued that, heating, to 400 degree Fahrenheit to 850 degree Fahrenheit, mean that the dough must reach the stated temperature. As a result, the dough would be burned to a crisp. Therefore, patent is invalid and there is no infringement. The plaintiff engaged an expert witness, a baker, to help. The expert commented, heating dough to 400 degree Fahrenheit to 850 Fahrenheit would burn it. Therefore I conclude by deduction, this should be the oven temperature setting and not the dough temperature. Based on the expert testimony, the court makes a judgment. Expert confirmed that there is no special meaning to the word heating to. Therefore dough, heating to refer to the temperature of the dough. This is different from heating at, which means setting the temperature of the oven at 400 degree Fahrenheit to 850 Fahrenheit. The court decided that the patent is invalid and the plaintiff, Chef America, lose the patent litigation. Court also makes 4 important opinions. First, patent did not mention any setting of oven temperature in the specification. Therefore dough, heating to must mean the dough temperature. Second, this is not an obvious and harmless error. This is a serious drafting error that court cannot correct. It is the job of the patentee, and not the court, to write patent carefully and consistently. Third, if the expert is able to show that heating to, temperature of the dough, is used interchangeably with heating at, temperature of the oven, the outcome may be different. Lastly and alternatively, if the plaintiff admit that dough, heating to is a drafting error, it might have been a better approach. What can we learn from this litigation? 1. Never underestimate the interpretation of each words in the claims. In this case, heating to versus heating at. If some words can be interpreted in a ways that may weaken the patent, it will be interpreted in this way during litigation. 2. Patent makes no mention on the setting of oven temperature. If the specification said something like, the oven is set to 450 degree Fahrenheit, it would be different. 3. Patent has no drawing. If there is one drawing showing an oven with a display of the temperature setting at 400 degree Fahrenheit, it would be different. 4. Court said that it is the job of the patentee, and not the court, to write patent carefully and consistently. Consistently means that every words used in the claims should be used and described in the specification. Lastly, even big companies with top lawyers can make serious drafting error related to patent inconsistency.